Good morning, friends. Namaskar, Sat Sri Akal and Adab. This is my 225th video, and this video will be exclusively made on why sale permissions are not given within the cantonments and what were the rules which were drafted by the Britishers or the Governor General orders starting from 1789. So this is a very important video on NOC, what the Ministry of Defence presently after 1947 persists on any bungalow or any property to be sold within the boundary pillars of the cantonment of yours. So what were the general orders? Let's go 27th April 1789. It said no private bungalows or buildings to be erected within the limits of the cantonment unless the permission of the Commander-in-Chief. So if you subject this, it says no private bungalows and buildings. So that means today what the government says, that we are the owners of the building or the bungalow, but not of the land. But here it says even we could not do it without the permission of the Commander-in-Chief. So this private building which was in existence was not allowed to be sold without permission. Now that means by the permission of the Commander-in-Chief, there were bungalows or there were buildings which were private. Now the extract proceedings of the Governor General in Council Order 25th June 1801. What is it saying? It is highly advisable not to grant any of the grounds within the limits of the military cantonment for the purpose of making gardens. Friends, this 1801 is very important. It says military cantonments. It is not, however, His Excellency intention to deprive an officer at present possessing gardens within the limits of a military cantonment of the use on the ground upon which these gardens are situated so long as such ground shall not be required for public purpose. Now here there is something very vicious if people can understand. That means if a bungalow was constructed as per the grant size, it had gardens or it had fields around it. Let's say the grant was of 1.2 acres and the garden was about say 5 acres, 7 acres. So this is what the restriction. And the Commander-in-Chief in 1801 says that these gardens can be acquired or resumed for public purpose. Where have the officers, now the question rises, purchased these gardens? And second, if these are required, will they be resumed from the original proprietors or the present proprietor, which is an army officer? So again we have an extract proceedings of the Governor General in Council 18th February 1802. Such bungalows at the station of Barrackpur as be for sale are to be effected in the first instance, which have to quarter the army officers. This is confined to native co-op officers. So they were in 1801 or 6 and on, there were even native officers who were along with the British officers posted in these various cantonments. Now again in 28th September 1807, any sale of building happening in 1807 will be only done after the fixation of the valuation of the building. And who will do it? It is the Committee of Arbitration. Then only the disposal will take place. So again it says there is an involvement. Somebody has to in 1807 by the orders of the Governor General, either the Commander-in-Chief or the station commander or then the brigade commander or anybody had to fix the valuation of that building. 31st July 1811, the general orders of the Commander-in-Chief, government having approved and confirmed the local limits. Now in 1811, minus the military cantonment, there were local limits assigned to the undermentioned cantonments and garrison by the joint report transmitted to headquarters by the civil and military authorities at those places respectively. Commanding officer in the station referred to are directed to cause pillars of masonry of a suitable construction immediately. So that means in 1811, the cantonment boundary pillars and the military boundary pillars were supposed to be created. I have had these videos, most of the people have been watching. What is the differentiation between a cantonment boundary pillar or a military boundary pillar? So now on 16th September 1833, the general orders of the Commander-in-Chief says that there has to be a register of houses. Okay, so the Commander-in-Chief is pleased to direct that every station will keep a register. So this is somewhat your land record, or let's say a property register. I will not call it in 1833 a revenue record. So stations like Dehradun, Dum Dum, and let's put it Barakpur, Danapur, Banaras, Kanpur, Agra, Meerut, Karnal, all sales of houses and bungalows or gardens within the limits of these cantonments now. Now it does not speak specifically military cantonments. It says either. And in order that these registers may be as complete as possible, the present proprietor of the house, etc., will be sent to the different staff officers a memorandum stating when they purchased or became proprietors of them, from who they obtained them in dimensions of their different compounds. So 1833 is vitiating from the 1810 PWD regulations of the fixed size of grants. Why? Because it is said that the house, bungalows or gardens within the limits of the cantonments. In future, when any house or piece of ground within the cantonment above mentioned may be sold or transferred, the person who makes the transfer will report the circumstances for the officer commanding. So here there was no restriction of sale. So 1833 till there was no restriction. So when did restrictions flew in? There came the Governor General Order. There was an earlier order also of 1827. We'll discuss it in the later part. And of Bombay Presidency. Now this GGO 179 of 1836, 12th September. Now this says it rescinds all earlier Governor General orders. So that means from 1789 or 1763, all Governor General orders are diminished? Or is it replicating to any order which was for Bengal Presidency? Because he says in this line, in this presidency is in regard to the occupation of ground and disposal of premises or buildings situated within the limits of the military cantonments, and to substitute the following regulations, which is to have effect from date of promulgation at different stations. So promulgation would be like you inform or you paste, it automatically becomes enforceable. Some people have been interpreting promulgation kind of a notification. Like I was reading a judgment of Librian case in Ambala. It says that GGO 179 was never notified for Ambala Presidency. I have the notification order of the 1954 amendment of the Governor General Order 1836 notified for Ambala. So let's not remain in those fancies that this GGO becomes redundant by no notification. So what do we read? The limits of military cantonments. Where are the military cantonments limit? As per the 1811 order of the Governor General, 31st July. Government having approved and confirmed the local limits, it very clearly says what I just read. So friends, we only have to understand the chronology, how the Britishers interpreted their own laws which were subjected, let's say in 1763, 1793, 1802, 1836 and further on. So why were these regulations being upgraded, our Governor General orders being upgraded? Because these were statutory laws, had to be enforced till the merger of the three presidencies and the armies. So now this proclamation was done as per Regulation 6, arbitration in case of transfer early. Let's say if there is a transfer of house to a civilian, if the ground has been built upon, the buildings are not to be disposed to any person. Now 1836, he says if a house is already built, so that means we were not given a grant, what the judgments and what the orders plead, we were already given a grant of a built up house by the 1836 government. Or were we given a ground and then we built this? This needs to be interpreted whenever the description does not belong to the army until the consent of the army. So simpler, the commanding officer has to give us a sanction, and that's how this further goes on. So this is very important. What were we allowed? Were we allowed to inherit a grant not given from the original tiller or the original proprietor? Was a major, colonel, lieutenant allowed to purchase the bungalow or house or the old grant from the original owner, and then he built a house, and then subsequently this house was transferred under this grant GGO? Or was it GGO 179 was a fresh grant given to a person first time of a land which was presumingly or totally acquired by the government or resumed by the government of the cantonment military? And now it says in its fourth regulation, if it has to be transferred to an army officer then no permission is required. But the minute the value goes above 5,000 rupees to a native from an army officer, permission is required. So let's say if I sell my bungalow for 4,900, I don't need permission. In 1836, not today. So these issues need to be, why permission? Why? So what do? Do we go to the court? And do we ask the court to interpret these various regulations from 1855 of Bengal, which is in my record, and Bombay 1855, Madras I have 1875 onwards. So let's dig into some army regulations which I saw them lying in the National Library, Calcutta. So now there is another order which was for Bombay presidencies. This was on 6th January 1827. This is Governor General Order 14. Now, does the GGO 179 rescind this order? No. I have a GLR which still says that it is a grant under the 1827 order. It's of Pune cantonment. So, this dispute is to be vetted. So jurisdiction has to be brought in, whether these grants were within the military station or were these grants within the entire cantonment after the civil and military administration had fixed the boundary pillars as per the 1811. So these many questions need to be answered. Similarly, there was another GGO which was made number 260 dated 7th May 1838. Again, this GGO subjectively says for Bombay Presidency. Again, it says the various orders in force in this presidency in regard to occupation of grant and disposal of premises of building within the limits of military cantonment are rescinded and the following are substituted. So, 1827, 1836 and 1838. So, here we have to speak after these 1827, 1836, but we have an 1833 house property register prior to 1827. So these are intermingling. So that means Bombay Presidency was separate, Madras was separate and Bengal was separate. And every Governor General or the Commander in Chief was governing his presidency as per his Governor General orders. Because if you talk of 1827 Governor General order for Bombay Presidency, then you cannot subject the 1833 House Property Register there, which was specifically made by the Governor General for Bengal Presidency, or the 1836 GGO. How can that be applicable in Bombay Presidency there? There came the Army Regulation and the Governor General order on 17th April of 1849, number 71 for Madras Presidency, and it says grants of land, again military boundary pillars, have to be marked with respect to land not the property of government within the fortress or cantonment. Application shall be made through the collector and board of revenue office. So Madras Presidency, yes, what the Secunderabad Association speaks, it speaks by this order and the Nizam's status that no grant in the Secunderabad Cantonment or Aurangabad or Kamti, which were part of the Nizam Presidency, were given by the British or the military or the Commander-in-Chief. They were given through the collector or a board of revenue officers, and then this was subjected to a no objection from the commanding officer. So we finally have an admission that private lands in cantonments existed. So now if we talk of the uniformity of these grants, again we have Army Regulation of 1887 Madras. It clearly speaks of cantonment boundary pillars and military boundary pillars. All private lands are exempted from the liability of resumptions in sale and purchase NOCs. So we conclude somewhere here till 1887 or 1849, there was no permission required. Proviso you were a grant under the GGO 179 1836 or 1827 or 1849 or 1838. So friends, it is very important to understand that there were no permissions required till 1887 when the mergers of the three presidencies were done. No NOC was required, no sanctions. It was only like if you have sanctions or permissions to be taken in Hudda, Pudda or any DDA property, you have to get an NOC, you have to pick up a sanction. So interpret these words. Now, when it clearly says till 1887, the Madras Army Regulation and the Bengal or the no NOCs were required, no sale permission was required. Proviso you were not under the GGO. Now, what happened after that? The Cantonment Code came 1899, then the Cantonment Code of 1912. These were the first kind of land records being prepared. And here what the Britishers smartly did, they converted these lands into leases. So they took my old grant, subjected me to a notice, and they said get your lease grant converted into a lease. Whether perpetual, whether 90 years, subject to 30 years of renewal, 1899. But there was a clause kept in either 12, 14 or 18 that my lease can be resumed after giving 1 month. The same language was used which is used in the GGOs of 1827, 1836, 1838 and 1849. How? And why, if I'm an old grant, not subjected to the GGO, how automatically in 1899 I become subject to all this? So we people didn't understand. 1899, I can understand how many people in India were educated. How many people had the status to be in these cantonments? Not even 1 or 2% of the total population, which must have been 20-30 lakh crores, or not even that. So the question is, now with the incumbent Cantonment Act 1864, nowhere in 1864, 1880 it talks of any permissions. It talks of registration. It gives the power to the cantonment executive officer, the powers of a sub-registrar. Till 1924, read any sale deed, it would be registered by the sub-registrar cantonment magistrate. Why? Why was he registering these sale deeds when these were grants? Why didn't he take permission from the... So one needs to understand. So there was no permission required. It was subjected to Rule 15 of the CLA rules. I'm finally straight coming to CLA rules in 1937. Sale of land, prohibited. For any purpose without definite orders of the central government is prohibited. One, the rules in chapter 5 not only apply to land placed under the management. So why is land placed under the management of the MEO within a cantonment? Because land doesn't belong to us. The Defense Department letter number so and so forth, May 1938, see sub-rule note 3 of rule 9, but also apply mutatis mundis under rule 47 to land entrusted to the management of cantonment board under sub-rule 5 of rule 9. So now in 1937, the civil area was given to the cantonment magistrate and the MEO was given the bungalow area. I will not call it bungalow area. Now I will start calling it House Accommodation Act area of the 1902-1924 Act. Friends, understand this interpretation, and if you can understand, you will really work it out. Well, now what is Rule 9 speaking? It says management of land, class A, 1 land except such area or classes. So, what was entrusted to the MEO and DO or the cantonment magistrate under? So, B3 landowners were never entrusted to the MEO. Why? I can explain it. We'll have to go back to the letters of 1925, how after the 1924 Cantonment Act things were changing. So these are the questions which we all need to answer. Now, what do we need to know? Are we private lands in the cantonment or in the via grants under the military cantonment? Were these gardens converted into houses, or were we actually old grants? This is what the GLR says of 1793 and on prior. And these old grants were purchased by the British officers through a board of revenue of officers as per the 1802 order of the Governor General. Or were we placed under the cantonment boundary pillars as per the Governor General or Commander in Chief order of 1811? These many questions need to be asked. So, grants which the Britishers wrote were after 1765 or 1793, which I had discussed in one, the Badshahi grants and the non-Badshahi grants. So were we actually the old grants? Because within the cantonments, as per Baden-Powell, there were never settlements done. So there are so many questions. So these pleadings have to be taken very subjectively in any of our cases. So why do we call ourselves, or why are we subjecting ourselves to either of the categories in B? See, we are not C lands, we are not A lands, we are B1, B2, B3, B4. Why are we accepting? Can't we say we are category 3 lands? So we need to understand all this. Now, on one side we get permissions with an NOC or with the Ministry of Defence to sail, and the other side the 2006 Registration Act 354 clearly says. What does it say in its sub rule 1, para 2 and 3 of section 54, 59, 107, 123 of the TP Act is applicable in the cantonment for a registered instrument. And what does most of the judgment says? That under the Crown Act or the Grant Act 1895 section 3 says TP Act is not applicable on grants. So the registrar or the sub-registrar of the district formed for the purpose of registration of 1908, 1877. This is not written in this section, which needs to be written, in which any cantonment is situated shall, when any document relating to immovable property within the cantonment is registered, send for information through the registration authority to the CO or the DO, MEO, and such authority as the central government may prescribe. So in our case, prior to 1924, it was the cantonment magistrate. After 1924, it is the district collector or the DC, whatever collector, whatever you may be speaking in your area. So once a registry is registered, the same document goes to the department to make its entry under the mutation register. I am not talking of the GLR register. So government is claiming that since we are old grants under B3 land category under the management of MU, so the Registration Act 354 is applicable on us. What are the facts speaks? Have we been easily countered? Could this sale permission come through easily? Have in the last 15, 20, 30 years, how many people have got sale permission? Only the powerful, connected straight to the government or the ministry. You have generals, you have businessmen, you have people sitting on top posts. They get permissions from the MOD. Why? Recently I got some religious institutions have been given permission by the defense minister then and now. So how? Why this discrimination? We need to all really work hard on these issues, and then only we can say that our violation of our rights is being done in these cantonments. And we admittedly let these rights get jeopardized of ours. Now later, basically after 1925-24 Cantonment Act, when the subjection was very clearly admissibility to the fact that now let's change the land record or the record of rights, and then the GLR of 1929, when land revenue or land special officers were deputed by the British for various cantonments. I have 4-5 reports. When they were preparing the GLR, they clearly said, anybody who has a problem, kindly please raise your objection. That we are going to write that in GLR that land belongs to Government of India, Union of India or whatever. And you are old grant, which we were. So the Britishers left a window open for us, that they wrote us in the GLR old grant. Why didn't they write us grant under GGO 179 there? Why in the remark column they come up and write that an admission has been given? Why don't they talk of the 1833, 1899, 1912 registers of private lands? Somebody just shared me from Mathura his original 266 register of cantonment lands in Mathura, and I was stunned that register people keep harping on. There is somebody in Varanasi who's harping a lot on this register 266. He doesn't interpret the status that that register meant only for leases. Is the government trying to say that these old grants were leases? That is why we were subjected to the lease section of the register. If we were an old grant, we could not have been a lease. There is a stato difference between an old grant and a lease. So how come our entries are shown in a lease register? Please understand, yeah. You know, sometimes I keep telling people, nowhere it is said that we require an NOC. Nowhere it is said that TP Act or Registration Act starting from 1877 to 1908 and prior 1864. I have an order of 1855 which clearly says any sale within the cantonments or anywhere would be a registered document. TP Act was not there, so how come these documents were being registered? I just came across a document of Aurangabad where it clearly said under the Nizam presidency the sale was done in 1909. So if it was India, Bharat, so how come the sale deed was being done under the Nizam presidency? So these questions can only be answered, and permissions for sale is not required. I am blankly saying this. But proviso that you people understand, we unite. We all need to unite. So we have to wake up. You know, unfortunately, the order of Varanasi, which is killing us, that went against us of Mr. K.K. Jain, that no sale can be done without permission. Similarly, we got an order from Jhansi. So why all this? Yeah. Like earlier we were divided into 3 presidencies, today we are divided. I'm surprised we are even today divided within the cantonment. Just recently in Jalandhar I came across such situation. There is a bunch of people who are fighting some resumption cases there. They do not want to share those documents with the association up there, because the association has refused to go for a legal battle on behalf of the association. We'll reach nowhere. A lady in Mau cantonment is facing all the rut, but either she's looking for a free pasture, people guide her, but guidance doesn't get you anything. You need a full-time consultant. You need somebody who can join these 4 corners and brief you to that. By just pleading something, by just admitting into B3 and GGOs and CLA rules. So what are we actually looking? Let us try and win over these small issues. Could be an NOC from LMA, NOC for sale from MOD. Can we sell or purchase an OGB bungalow? Can we mortgage the same bungalow? Can we stop being called grantees or licensees? Can we call GLR a revenue record maintained by the Patwari or the Tahsil in a simpler manner of any land outside the cantonment, or could we call it a record of rights? So these questions have to be interpreted. Then only can we counter the GLR, which has been upheld in 2001, Surinder Kumar Vakil. So we have to go stepwise. So please friends, please understand what is cantonments, how the creation of these military stations was converted into cantonments. These were basically military stations. And from there they were getting converted into cantonments, because the natives and the British even wanted for their odd jobs civil areas or bazaar areas where these people could come, those were out of bounds areas, and do their odd jobs in the bungalows. So NOCs, Governor General orders, boundary pillars. How do we understand military boundary pillars or cantonments? And after the making of the Indian Council Act in 1861, Will the Governor General orders, if they were notified or they were rectified or they were modified, like the GGO 179 has been modified till 1864. So we need to understand these. Why house tax was being charged to us after 1880? What does the tax structure of 1902 speaks? Why bylaws were being made? Do you get to see bylaws made for any government land? No. Bylaws are made for private lands. So whatever the powers of the sub-registrar from 1864 to 1924, what is the land record system from 1899 to 1912? So what really changed? Why sales were getting restricted from 1937 onwards? Because there the GLR of 1929, the 1925 CLA rules GLR is not available to us mostly, and that GLR was not being maintained individually. It was being maintained in a column wise of all the house numbers. Earlier they were called house numbers. We were neither holding any survey numbers prior to 1925. So please, and mutation is very important. So we have to understand from 1806 the Bengal Regulation 17, which speaks of registration of deeds, and 1877 Registration Act to 1908 and finally the TPA Act. So these many topics have to be discussed. So if you want, I can quickly give you a brush. We must all know what are the station commander's duties. Try and read chapter 5 at page 363, para 8, role of station commander. Page 363, what can he do? Page 364, and role and powers on page 369. So you will understand the responsibilities. So now the station commander is restricted. Now when you see the disposal of records, page 407, para 30, what is to be permanently kept and what can be disposed after 10 years. Management of land. If you read chapter 11, you will understand how on page 429 surplus land has to be declared within the cantonment, and then we have finally an executive order which says don't declare surplus land. CLA rules guarding us under 287 1924, Registration Act which is 354 in 2006. So read these. Read the land policy at chapter 14, page 558, para 8, proposal of conversion of freehold. Chapter 15, vacuum properties. Chapter 17, cantonment code, leases, page 592. Unregistered written acknowledgements from government, para 1 of page 593. This is admissions. Advisable, para 2, para 3, subdivisions of land or old grants. Mutations of bungalows, NOC from army. Chapter 17, cantonment leases, para 39, page 632, mutations, how they can be done and what is to be demanded. Chapter 24 becomes very important, delegation of powers, page 776, para 34, who has the power to mutate you. Chapter 25, hiring and requisitioning and acquisitioning of bungalows, which has now been converted into an hiring and disposal act. This was originally the rape act. So now KLP had to be calculated as per the orders of the 1947, subjected to later in 1990 order also. So new land requirements, KLPs, old policies, everything is on the book. But who reads? Everybody waits. Let something happen to us. When our ass is on fire, then we'll propel. So friends, please try and understand, we do not need an NOC if we admit to ourselves we are a private land. Yes, it is right that after the Allahabad judgment of Varanasi, Jhansi and various orders, it's become very difficult to entertain a sale deed. So we can always go to court for this. Court can subject us to say why NOC is required. So these points can be briefed there. Once again, I am saying we are revenue free grants, we are old grants, never converted into new grants by the Britishers, because we were proprietors of our grants, and these grants were purchased by the British officers, which meant they built a house on my garden or my field. That's how things happen. Good day. Thank you.